You may be wondering, is it the right time for me to get an estate plan for my family? And I wanted to go through a couple of things that are important to think about when you're thinking about getting an estate plan for your family and for your business. So most of our clients come to us about the time that they are done having kids. They may be, they may own a practice, they may own a home, and about the time that things are starting to settle down as far as that is concerned is when a lot of young families are starting to think about creating a will, creating a living trust, and other related documents. So I wanted to go through what an estate plan is, what does it consist of, and what are the pros and cons of it. So when we talk about estate planning, we're really talking about a couple of documents. We're talking about a living trust, which we'll go through in a second. We're talking about a will. We're talking about powers of attorney for healthcare, and also powers of attorney for financial matters. So those are the four main pieces of document that comprise of an estate plan. There's a lot more that we draft for you that are documents that are related to an estate plan that you must have, but those are the four main ones. So let's go through each of them. The powers of attorney for financial and for healthcare are for times when you might be injured or you may not be able to make decisions on your own and you need someone else to help you make those decisions, whether it's for healthcare reasons or for financial reasons. So in these kind of situations, you may be hospitalized, you might be sick, you may be out of the country and not allowed to return. So it might be any of those occurrences. If, God forbid, you pass away, that's when the living trust and the will come into play. And the way this works is that with a living trust, you transfer all of the assets that you own, anything that increases in value. So that could include jewelry, real estate, potentially your business, and anything else that you have of value, whether it's sentimental or actual value, monetary value, gets transferred into the living trust. The living trust is a separate organization. It's a separate entity that you govern. You and your spouse would manage that entity together while you're alive. Inside that entity resides all of your assets. Now, the great news about living trusts is that you don't lose any of the tax benefits. So if you have bought that house, let's say as a married couple, you still get all of the same federal and state tax benefits that you would get if you held it in your own name. But it resides in the trust as a separate entity so that if something should happen to you, your successor trustees, now a successor trustee, that's just a fancy word for someone that you've designated to take over management of your trust, okay, management of your trust after you and your spouse pass away. And by the way, we always assume that you and your spouse pass away together because if only one of you passes away, the trust would always defer to the other spouse until they pass away. But assuming you both pass together, then the successor trustee steps into your shoes and works to, in essence, make your wishes happen. And that's where you designate how much you want, if you've got children, how much you want your children to receive, at what age you want your children to receive your assets, if you want your assets to fund their education, and any of those other details. If you don't have children, for example, you can donate your assets and your income to a charity or to any other third party, whether it's family or friends. Okay, so that successor trustee is very important, and usually we recommend that you name several trustees beyond just one, in case that one trustee that you've named, the first successor trustee, isn't able or willing to do their job. Okay, so that's the benefit of a living trust. Now, there's a lot more detail to that, but that is the crux of it. Now, a will, which for when you have an estate plan, it's really called a pour-over will, because the assets that are not in the trust, the things that don't increase in value, such as furniture and cars and other things, get dumped into the trust through the pour-over will. The pour-over will is also where you name the guardians for your children. And so this is very important because the decision of who's going to raise your child and who's going to be responsible for them, especially if they're minors, is a very difficult, sometimes and long process for families because there's a lot of complexities that can come into it. There's a couple of keys to know about this. One is that whoever is the guardian of your child or your children doesn't have to be the same person who's the trustee. In other words, you can have someone who's really good with money and really good with business and those kinds of things and is very organized to be the trustee of your trust, because there's going to be a lot of paperwork and there's going to be a lot that they have to do there. And then you can have someone in your family that's really great with children, or has a special relationship with your children and can raise them, and those two people can be different people. In many families, they are different people, by the way. And so there's no harm in having it be separate individuals. The key to know is that you want to make sure that those folks get along, right? Because they're going to have to work really closely together to make sure that the children have everything that they need and that your wishes are abided by. So keep that in mind. So those 4 documents: the living trust, the pour-over will, the powers of attorney for healthcare, and the power of attorney for financial matters are the 4 main documents of a strong estate plan. So you might ask, what are the drawbacks of having an estate plan? Well, there's a lot of work up front to put it together. You have to fill out questionnaires with us. There's a lot of meetings that we need to have to discuss the details of it. You, as a family unit, have to have a lot of discussions. You got to talk to your potential trustees. But beyond that, there's really no downside. And so you get to really protect all of your assets if something unfortunate happens to you, and you get to pass it on to your beneficiaries with very little risk. The primary benefit, though, is that you get to dictate who your assets go to, and it's a confidential matter. It's a confidential matter. So the public doesn't know what's going on with your assets. It just gets transferred through the trust. If you don't have a trust, your assets go through a process called probate. And probate is a public event. It's in the court system whereby your assets go through the system, and the courts figure out how much is left for your beneficiaries, how much goes back to the banks, and vice versa. And so sometimes, a lot of times, you end up having people who just want to take advantage of trustees and beneficiaries come out of the woodwork because they see how much assets you have and what's being transferred. So to keep it confidential, you want to avoid probate, and you want to have it inside a living trust. Other than that, on a year-to-year basis, it's very easy to maintain. The only times you need to change anything is when you add assets to your estate. You buy an additional home, you sell your home, you increase the value of your businesses. Things of that nature are the only times you need to edit a living trust. It's a great tool to have, very flexible thing to have, and very straightforward. So we highly recommend it for any young families who are done or believe they're done having children and own a home and a business and are ready to protect all of that. If you have any questions about any of this, you want to go into great detail, don't hesitate to give us a call.